Chicago-Kent Supreme Court Review. My name is Greg Barbikoff. I'm the president of the American Constitution Society here at Chicago-Kent. We're proud to be co-sponsoring this with our counterparts, the Federalist Society, also here at Chicago-Kent, clearly. And once again, we want to thank you all for coming. We have a great discussion lined up with several of the court's most pressing, I would say, persuasive and highest impact decisions from the 2009 term. Leading the discussion is going to be Professor Schmidt and Professor Nahmod. So, I'd like you all to enjoy the panel discussion, and we have some great food lined up for afterwards. Please feel free to stay about for as long as you need afterwards. Make sure that you get a little bit to eat, and enjoy.
Okay, I've picked 3 cases to talk about today from the last term of the Supreme Court, and just to try and engage the audience, today we have the topics of guns, money, sex and violence. Sex and violence together in the last term, the last case. The guns first. McDonald versus Chicago. This case is a logical extension of a case that was decided 2 years earlier in 2008, District of Columbia versus Heller. In the Heller decision, the Supreme Court held that the Second Amendment protected individuals' right to bear arms, and this right included the right to have a handgun in the home for purposes of self-defense. The Heller decision, it's important to note, was seen as a major victory for originalists. Both the dissent and the majority of the opinion argued largely around questions of original meaning of the Second Amendment, questions of what the intentions of the framers was, and how the Second Amendment was viewed by people who ratified the Constitution. So a lot of people see this as a great triumph for originalism as a methodology. I'll talk about that a little bit more in a minute. The Heller case left 2 big questions unresolved. One is the scope of the Second Amendment right to bear arms. The core of the right, quite clearly defined in Heller, was the right to have a handgun in the home for purposes of self-defense. On the other end of the spectrum, the court explicitly recognized that certain regulations would pass constitutional muster. Heavy artillery, not necessarily included as a right in the Second Amendment. Regulation against gun ownership by felons or mentally ill was accepted as a reasonable regulation under the Second Amendment. And there's also the recognition in Heller that guns can be regulated in certain areas, such as in government buildings. You have regulation prohibiting guns in that area. But between the home self-defense handguns and these certain accepted long-standing limitations, it's really unclear exactly what the scope of the Second Amendment right will be. The other issue that was left unresolved was whether the Second Amendment was going to be applied to the states. And this is the issue that was at the heart of the McDonald versus Chicago case. Keep in mind that the Second Amendment on its face applies only to the federal government, and Heller has to do with the District of Columbia, which is controlled by Congress, and therefore didn't need to get into the question of the application of the Second Amendment to the states. So in McDonald, we have the challenge. The Chicago handgun ban was passed back in 1982. This is a question which is oftentimes referred to as incorporation. The specific question is, does the 14th Amendment somehow incorporate the provisions of the Bill of Rights, in this case the Second Amendment, and thereby take the Bill of Rights protection and apply it not just to the federal government, which is clearly what the Bill of Rights does, but also to the states. Most of the Bill of Rights have been incorporated. Most of the incorporation, or all the incorporation that has taken place through the due process clause of the 14th Amendment. This is a piecemeal process that started back in the 1920s and continued mostly through the 1960s, is where most of the action took place. The basic question justices consider is whether the right at issue, the Bill of Rights provision at issue, is fundamental enough in these different phrases that they use, the scheme of ordered liberty, to justify incorporating it and applying it as a national standard to the states. This issue simply hadn't come up with the Second Amendment because the Second Amendment hadn't been held to recognize an individual right before 2008. So this is a new issue. It's sort of, in some ways, exciting that a new incorporation issue would arise because it was thought that most of them had already been resolved one way or another. This case also is interesting if you're interested in originalism as a methodology of constitutional interpretation. Because in Heller, the original argument, the originalist argument, was all about the late 18th century. It was all about 1791 when the Bill of Rights was ratified. In this case, you actually have a different originalist analysis because the core of the issue is all about the 14th Amendment and whether the 14th Amendment incorporates the Second Amendment. And this has to do not with the late 18th century, but with the Reconstruction era. 1866, when the 14th Amendment was drafted, 1868, when the 14th Amendment was ratified. So you actually have a whole different area of historical analysis that's brought into discussion in this case. Now, the really interesting aspect of the McDonald case from a legal analysis point of view is not the outcome of the case. The outcome of the case was pretty clear. I didn't really have any doubts. I don't think anyone else really had any doubts that in the end, a majority of the court was going to find that the Second Amendment was going to apply to the states. It just didn't seem like the justices who wrote Heller would find, for some reason, they weren't going to make this into a national standard. But there was a question about how they were going to do it. And the reason this was interesting is because although the Due Process Clause has been the mechanism by which the application of the Bill of Rights has been brought into the states, there has been a move to try and find another constitutional provision to make this happen. Specifically, there's a provision in the 14th Amendment called the Privileges or Immunities Clause. Now, Privileges or Immunities Clause, if you go back to the framing of the 14th Amendment, most of the people who wrote the amendment thought the Privileges or Immunities Clause was going to be really important. That a privilege of national citizenship would include things like perhaps a right to bear arms, perhaps a free speech right. Most of the rights that are embodied in the Bill of Rights, the people who wrote the 14th Amendment would see as incorporated in the 14th Amendment, but not through the Due Process Clause, which again doesn't really make a lot of sense. Due process has a rather clear procedural connotation, but through the Privileges or Immunities Clause. So this, as originals matter, would seem to be the most promising way for incorporation to take place. It hasn't gone that way. And it didn't go that way largely because in 1873, the Supreme Court decided a case called the Slaughterhouse Cases, where they basically read the Privileges or Immunities Clause out of the Constitution. Just said it has a very limited meaning and certainly is not going to cover provisions of the Bill of Rights. A lot of people saw McDonald as an opportunity to go back and revisit the Slaughterhouse Cases. The Slaughterhouse Cases are seen, widely seen among historians and academics, as just wrongly decided, a wrong reading of the intentions of the drafters of the 14th Amendment or any sort of original meaning. So it was proposed to the court that yes, by McDonald's lawyer, that yes, you should incorporate the Second Amendment and apply it to the states. But why don't we actually go back and correct this wrong road that we went down a long time ago and try and correct this constitutional doctrine to give it a more solid footing? Thinking that with some strong originalists on the court, again, look back to Heller. Heller is this great originalist decision, this originalist victory. If you want to be true to originalism, it would seem that going back and resuscitating the Privileges or Immunities Clause might be a beneficial move. Now, this is also an interesting move, not just for sort of doctrinal clarity. Just, it'd be nice to just have doctrine make more sense, be more true to the history. There are also larger implications at play in this call to resuscitate the Privileges or Immunities Clause. A lot of liberal law professors, who are not necessarily originalists, got on board the Privileges or Immunities bandwagon. Why would they be so concerned about this? Partly because they recognize that the due process path is unstable. It's a strange way to deal not only with questions of incorporation, but also questions of unenumerated rights in general. You remember cases like Griswold, the right to privacy, Roe versus Wade, the right to abortion, Lawrence versus Texas, which finds protections against prohibitions of sodomy based upon some principle of liberty or privacy. All these are based on unenumerated rights, and all these are based on the Due Process Clause. But this has been a rather tenuous footing for the location of unenumerated rights in the Constitution. So people actually embrace the idea of finding certain basic unenumerated rights, see this as a better way of going. Right? So this is why sort of both the right and the left, both originalists, which tend to be on the right side of the spectrum, or liberal constitutional scholars, they all saw something beneficial in this. So it was put forward, and it was briefed at length. And then the lawyer from McDonald stands up, begins to quote from the Privileges and Immunities Clause, and Scalia cuts him off, and essentially says, "What are you doing?" Now this is interesting. Scalia, right, the great patron saint of originalism, is getting an originalist argument, which is really a good originalist argument. I mean, there's no real question, it's correct. And he sort of makes fun of the lawyer, saying, "What are you trying to do, get a job in law school faculty?" Which I thought was a great slam. Yeah, the last thing, but so, who are you talking to? You're not talking to us, you're just talking to your friends, trying to make these clever arguments. We've been doing due process for a while, we're going to stick with due process. So Scalia sort of cut that off at the knees, The court rejected it. One justice was on board with this resuscitation of privileges and immunities, particularly as Justice Thomas, who is the most committed originalist on the court, actually goes beyond Scalia in his commitment to originalism. But this wasn't really going to happen. Why? Why such a concern with this? Well, I think part of the answer probably goes back to that reference I made to why some liberal constitutional scholars liked privileges or immunities. It has the potential actually to be a more expansive basis for the location of unenumerated rights. Okay, most of the Bill of Rights have been incorporated, so that's an old story. But the question is, what if new rights come along? Sort of a living constitution concept. And I think Scalia actually hates the due process clause as a way of bringing in substantive rights, right? Substantive due process is something he thoroughly enjoys denouncing. But I think he actually likes having the discussion be about substantive process rather than privileges or immunities because it's more limited, right? You denounce it, you say we shouldn't add anything to it, and he can feel confident in dissenting in cases like Lauren versus Texas on just basic constitutional grounds. If you go back and actually give life to this old provision, privileges and immunities clause, in which there's originalist basis that perhaps they envisioned, the people who drafted that envisioned this as a home for certain unenumerated rights. That actually would be more threatening to a committed originalist. So Scalia didn't like that. Chief Justice Roberts, in oral arguments, actually said, the only reason you like privileges and immunities is because it's not as limited as due process. And the answer is, yes, but also, again, if you're committed to an originalist reading, it's more correct. I want to step back a little bit from this originalist idea because the fascinating thing about both McDonald and Heller, I mean, they're both originalist decisions in a certain way. But we do see originalism playing out in interesting ways. Again, originalism was pulled back on in McDonald, whereas Heller, it seemed like it was sort of full speed ahead. There's also this really interesting idea that originalism is committed to the idea that there is a core meaning to the Constitution that's unchanging. The problem is here we have an understanding of the Second Amendment of the Constitution that's pretty well entrenched for a long time, and then it changed. It changed why? According to the people who like to change, it changed because of originalist interpretation. But originalism in this sense is being used to actually change the Constitution. What is the basis for this change? You really can't explain Heller and McDonald without a recognition that there's been a concerted movement to try and get gun rights into the American consciousness and into the courts. It's a social movement that also has a legal component. And the victory of gun rights as an idea, as a political movement, quite clearly eventually had implications within the courts. So you have a social movement committed to legal change based upon the methodology of originalism, which is theoretically based on an unchanging meaning of the Constitution. But the whole point of this movement, this political, social, legal movement, is to change the meaning of the Constitution, which is actually pretty well settled. So there is this sort of irony within originalism, which is interesting to consider. That's guns. Money, Citizens United. I'm not going to talk too much about the law on Citizens United. I'll just briefly summarize it because I'm more curious about the way Citizens United has sparked a discussion about the court and constitutional law. So Citizens United was a case, Citizens United versus Federal Election Commission, decided January of last year, so it was sort of before the end of the term release. In this case, the court struck down a provision of Campaign Finance Reform Act, which said that corporations couldn't make independent expenditures from their general funds within a certain period before an election. Here, the court, legal reasoning is pretty clear. Campaign contributions is a form of speech. Corporations do have free speech rights, and this wasn't the first time a corporation was given some sort of recognition as having an expressive First Amendment right. But it was the first time in which this First Amendment right was seen as something that could not be regulated in the context of campaign finance regulation. So essentially it allows corporations to get more involved in elections. In this case, not necessarily contributing directly to candidates, but contributing to the discussions, putting up ads in favor of candidates or against candidates. This was a very significant change in constitutional law, so I think two important themes that you can pull out of the Citizens United case is one, the idea of judicial boldness. Right? A lot of people were angry at the conservatives in the court because there's a lot of talk among conservatives about judicial restraint. Chief Justice Roberts, during his confirmation hearings, as well as Justice Alito, but particularly Chief Justice Roberts, really praised the idea of stability of doctrine, of stare decisis, of the court playing some sort of less activist, more minimalist role. And in this case, there really was a lot of upturning of law in order to get to this particular decision. Right? The federal government has been regulating corporations in campaigns for a century prior to this. There was a Supreme Court precedent, about 20 years of it, that was overturned. So this is the sort of case people had hoped that the approach Chief Justice Roberts would take would not be necessarily how it would come out in this case. And Chief Justice Roberts clearly felt self-conscious about this because he signed on a majority opinion, but he wrote a lengthy concurrence trying to explain why this case was not a case where stare decisis was preferable. What I'm really interested in is a reaction to this. Some of you probably remember, President Obama was angry about this decision. He denounced it when it came down, and then he even used his State of the Union address to directly criticize the court, saying that this is a bad decision, this is going to have bad outcomes. And the striking thing is, the State of the Union, the majority of the court was sitting in the audience, 20 feet away from him. Now this became a little bit of a soap opera because when he said that, not unheard of, presidents have criticized Supreme Court opinions before in State of the Union address. But Justice Alito was in the audience, and he clearly got exercised by this criticism and started shaking his head and mouthed the words, well, it looked like that's not true, right? So with the cameras on him, this became one of the stories of Citizens United. So this is interesting to think about because you have the idea of the dialogue between different branches of government. The court issues a decision. It's important to recognize that that's not the end of the story. There are still other options to have. A simple option you can imagine was judicial appointments. Right? This could become a major issue for the appointment of new justices. And in fact, Justice Kagan, when she was appointed, talked a lot with Citizens United, quite clearly expressed her criticism of the case, and she was actually representing the government in the case itself. So she felt strongly that the government position, not the position that won out, was a better position. So appointments actually could be important going forward in this particular decision, because it's not a very popular decision. That takes time. The appointment process is just a slow process. We also could have a political remedy for this. Obama criticized it. Obama tries to get support for a movement against it. Congress considered a law that would disclose corporate expenditures in elections. So not necessarily overruling the decision, not necessarily directly challenging the decision, but trying to work within the confines of the decision to have more disclosure. Got through the House, failed in the Senate, and not likely it's going to get picked up again. So legislative remedy didn't seem to work in this sort of idea of a dialogue. Constitutional amendment. At the time of the decision, there actually was some talk about a constitutional amendment to try and correct what some people saw as the error of the decision. And there is some, it seemed like in the abstract this would be a possible thing because the decision, again, was quite unpopular. Opinion polls have strong majorities who are critical of this particular opinion. But you haven't heard a lot about the amendment process since then. The Constitution is amended very rarely. You couldn't even get the majorities necessary in Congress. In the Senate, you needed actually a supermajority because of the way the filibuster system's working these days. But you couldn't even get Congress to move on this issue. And it wasn't enough mobilization for an amendment. But it is just instructive to think about. You have a decision like this that does upset some apparently settled law. You have a political reaction against it. And there are challenges to try and actually get this political reaction off the ground, even though you have some strong majorities that are critical of it. So that's the money. Now we'll finish up with sex and violence. This is a case called United States versus Comstock, of the case I'm talking about, probably the least recognized one, but quite an interesting one, and I would say this is a case that was decided last term that could be the most prescient going forward for the cases, the major issues the court is going to be considering in the next few terms. And this case deals with the scope of federal power. This case involved a federal civil commitment law that allowed the Department of Justice to continue to detain federal prisoners if they were deemed to be mentally ill and at risk of sexual violence. Now do note, this involves just federal prisoners. So in order for someone to fall under the scope of this law, they already need to be in federal prison for committing a crime. So there's a crime that happened in the past. There's a prisoner in a federal prison. At the time of the release, the Justice Department can get a determination, and there is some judicial review to try and ensure procedural rights here. A determination that this particular prisoner is dangerous, and that this prisoner should not be out in society. So it would be under a civil commitment policy. This law is challenged under a number of constitutional claims, like a due process claim, some equal protection claims. The one that finally showed up in court in the Comstock decision had to do with whether Congress actually had the power to pass a civil confinement law. Where in Article 1 of the Constitution does Congress locate its power to do such a thing? So this is the case about federal power, not necessarily about individual rights, although there are individual rights claims in this whole scenario. The court upheld this particular law with a vote of 7-2. Justice Breyer wrote the opinion for the court, joined by Roberts, Stevens, Ginsburg, and Sotomayor. Kennedy and Alito wrote concurring opinions. Thomas, joined by Scalia, dissented. So the question is, where did Congress locate authority for this particular civil confinement law? The answer is in the necessary and proper clause. Right? Article 1, Clause 8, paragraph 18, the last clause. Now this is sort of interesting because you don't normally find a basis for congressional action in the necessary and proper clause alone. Usually there is an enumerated power, and then the necessary and proper clause is used to allow some sort of expansion beyond just the clearly enumerated power. So in the enumerated powers listed in Article 1 of the Constitution, there are things like you have Congress has power to create post offices and maintain roads between post offices. Now you can imply from this, right, using the necessary and proper clause on a constitutional basis, that if you have the right to maintain post offices, you probably have the right to deliver mail. If someone robs a mail carrier, Congress has a right to protect the mail, and they can make that into a crime. Nowhere in the enumerated rights does it say Congress has the power to make a crime out of stealing mail. But that is fairly implied from the text of the Constitution, the enumerated power to create post offices, along with the necessary and proper clause. But again, just note the move here. There is an enumerated basis to start the whole ball rolling. So you uphold the power of Congress to criminalize, or if you want to get closer to this case, to throw criminals in jail, to create federal prisons, to put mail robbers in jail. Right? All that would be an implication based upon the power to have post offices filtered through a necessary and proper power. So where is the sort of the firm ground underneath necessary and proper in a civil confinement case? There really is none. This is the striking thing about the case. The entire analysis is about the necessary and proper clause as the basis for this. And this is what the dissenters raised. Where are you actually finding the enumerated power? You can't just rely upon necessary and proper. The problem here is that the predicate power for this exercise of necessary and proper clause is sort of all over the place, right? Again, if someone stole mail, it might be the postal responsibility. If someone interfered with commerce or transported goods across state lines, it would be the commerce power. The reason individuals in federal prison in the first place has to do with all different provisions of the Constitution. And then the argument is that the necessary and proper clause then comes in, but it's not specifically tied. It's a little bit free-floating, which makes this a tricky decision. Justice Kennedy and Justice Alito both concurred, saying that I do think there's a federal basis for this, but they both pulled back on some of the broader assertions of federal power, and Thomas's dissent just said you need to find specifically enumerated power, otherwise no law. This case does raise a question of the federalism revolution, which you've all learned about in constitutional law class, with cases like Lopez and Morrison, and then maybe qualified with cases like the medical marijuana case, the Rich case. And the big question is, where exactly has the federalism revolution gone? The idea that the court is going to be more active, limiting federal power and protecting state power. I think this does give some indication, although then you start reading the sort of tea leaves of the case, and some of the concurrences by Kennedy and Alito actually have quite strong states' rights language in them. Now, why is this interesting at this point? Well, again, on the horizon, we do have a challenge to the healthcare provision, the healthcare bill, particularly the individual mandate of the healthcare bill, and this is going to be squarely looking at federal power. So I think the Comstock case can be seen in some ways as not quite a dry run, but raising some of the issues that are then going to be followed through on in this case. I got to mention one more case, which is on the docket for this year, which is also in the realm of federal power. So we have the healthcare challenge, likely going to reach the Supreme Court in 2012. I will say that the challenge to healthcare in the courts, when the healthcare bill was first passed, most of the mainstream media said that this is a very long shot. Most legal academics said there's a strong basis for what Congress did is going to be upheld in the courts. Over the last 9 months or so, almost a year now, I will say the tone of discussion on healthcare has gotten more qualified. Right? I do think the Tea Party movement and the sort of populist conservative movement is having an effect just on people's sensibility about the idea of federal government power. And we do see that right now in the healthcare challenge. There are 3 lower court challenges. There have all been motions to dismiss the case at the beginning. 1 federal district court dismissed. 2 others did not. They said, no, we're going to go through. And the judges also expressed pretty critical language toward the government in terms of its justification for the health care bill. So the tide has shifted somewhat. I don't know if it's enough to actually change the outcome of the Supreme Court case. One last case. The case of Bond versus the United States, which is coming up this term. This is a 10th Amendment case. You don't get many 10th Amendment cases, and that's why this is sort of interesting and exciting. Facts of the case. Carol Bond tried to poison with toxic chemicals. She was actually a microbiologist in her real life. She tried to poison her best friend. Why did she want to poison her best friend? Her best friend also happened to be her husband's lover. And her best friend was not only her husband's lover, but was caring for her husband's love child. So Carol Bond goes after this woman with toxic chemicals. The state authorities do investigate, but they're not following through in the investigation, and it ends up that the federal authorities get involved and prosecute Carol Bond under Chemicals Weapon Convention. Right? I mean, this is overkill. Right? The person's not doing a good thing, but this is overkill. She ends up going to sentenced to jail, I think, for 6 years. The maximum if she had stayed in the state judicial system would have been like 3 years. So she gets a more stringent penalty because of the federal involvement. She challenges this conviction. And she challenges it based upon the 10th Amendment, saying the federal government did not have power to use this against an individual. This is a fascinating question. An individual has never been deemed to have standing to make a challenge based upon the 10th Amendment. I mean, it's just never happened before. It's a case of first impression. And the court just accepted cert on this particular case to investigate the idea about whether they're going to allow individuals to raise 10th Amendment challenges against prosecution based upon federal law. Again, federal government issues, scope of federal power, I think, is going to be a major issue in the coming terms. And I do think these help set the stage for what we're going to see coming down the pike. Thank you.
Good afternoon. Thank you for being here. I'm going to go through 3 or 4 First Amendment cases. The first 3 deal with free speech, and the last deals with the Establishment Clause. But before that, I want to make an observation about this current court. When Justice O'Connor was on the court, it was pretty clearly an O'Connor court. She was the swing vote. She was the one that the litigants would often appeal to in their briefs and oral arguments. These days, it is pretty clearly much more a Kennedy court. Of the decisions last term, there were 85 or 86 merits decisions. Justice Kennedy was in the majority in 91% of those cases. There were 16 5-4 decisions, and he was in the majority in the 5 in 12 of those cases. So what you do is appeal to Justice Kennedy. He has the swing vote, and interestingly enough, in all 4 cases that I'm going to talk about, Justice Kennedy was in the majority as well. So here are the 4 cases. The first one is the Stevens case, which is the Crush video case. The second one is the Humanitarian Law Project case involving the material support of foreign terrorist organizations case. The third one is Christian Legal Society, arising out of Hastings College of Law. And the fourth is the Salazar case, which raises the question of when is a cross not really a cross. But more about that in a few moments. I need to situate these cases, each of them, in First Amendment jurisprudence. So let me just give you a 30-second primer. Speech is protected, as we all know, by the free speech part of the First Amendment. It prohibits, that is, the free speech clause prohibits content discrimination by government and viewpoint discrimination by government. The primary rationales being the marketplace of ideas, willing buyers and sellers get into the marketplace of ideas and choose for themselves which ideas are valid or invalid. And another very powerful rationale is the Meiklejohn rationale of self-government. We know we need free speech in order to govern ourselves. The people decides. people decide what speech is valuable, not the government, and there is a hands-off approach that must be taken by government. Now, there are certain unprotected categories under the First Amendment, and that becomes crucial to understanding the Crush video case, the Stevens case. Obscenity is one, fighting words are another, true threats, child pornography, not ordinary pornography. In order to understand the Crush video case, the Stevens case, we need to say a few things very briefly about obscenity, which was defined by the Supreme Court in 1973 in the Miller case. Obscenity requires, at a minimum, that it be a depiction or description of sexual conduct, and that must be specifically defined. You all know a good deal of the three-part test. The average person applying community standards finds that the work as a whole appeals to the prurient interest. The sexual conduct must be described or depicted in a patently offensive way. And finally, the work as a whole must lack serious literary, artistic, political, or scientific value. The key is sexual conduct, depictions, and descriptions. Now, the general tendency, the general trend in the United States Supreme Court for the last 2 or 3 decades was gradually to remove more and more categories of unprotected expression, so that defamation was removed from the category of unprotected expression, New York Times v. Sullivan, and commercial speech was removed from that category as well in the Virginia Board case. One major exception to this trend is the child pornography decision in the Ferber case handed down in 1982, which held that government could prohibit depictions of a child or children engaged in sexual conduct, even if that is not obscene. Sexual performance was defined in that Ferber case as actual or simulated sexual intercourse, deviant sexual intercourse, sexual bestiality, masturbation, sadomasochistic abuse, or lewd exhibition of genitals. The question in the Stevens case was whether the obscenity rationale, and more particularly the child pornography rationale, Ferber and its rationale, could they be extended to communications describing animal cruelty, depictions, descriptions of animal cruelty, really videos for the most part. Here is the federal statute that was involved. It was 18 U.S.C. Section 48, which criminalized the commercial creation, sale, or possession of certain depictions of animal cruelty. It applies to visual or auditory depictions in which, quote, a living animal is intentionally maimed, mutilated, tortured, wounded, or killed if that conduct violates federal or state law where the creation, sale, or possession of the video, shall we say, takes place. And here, Stevens was indicted for selling videos depicting dog fighting. Stevens was a Roberts opinion. It was 8-1, and the Supreme Court said the following in striking down this federal statute on its face. The court said, first of all, it is not necessary here to deal with the question of adding depictions of animal cruelty to categories of unprotected speech. It tilted in the direction of saying no, in part because there's no tradition of prohibiting such depictions. Nevertheless, even though it didn't reach that question, it went on to find the statute unconstitutional on its face because it was substantially overbroad. What does that mean? It's a powerful doctrine in free speech jurisprudence. When a substantial number of applications of a statute are unconstitutional in relation to the statute's legitimate sweep, then that statute is facially unconstitutional, is substantially overbroad because it has a chilling effect on protected speech. The Supreme Court in the Stevens case went on to find, and the analysis is pretty complicated, went on to find that the statute was substantially overbroad. Because it was substantially overbroad, and this is important, the court did not decide whether a statute limited to crush videos or extreme cruelty would be constitutional. It did not decide that issue, and that's particularly important because Justice Alito was the sole dissenter. He argued for a narrowing interpretation of the statute, and he said, in fact, it can reasonably be applied or interpreted only to such depictions, crush videos and animal cruelty. In other words, it was not substantially overbroad, and by analogy to Ferber, the child pornography case, Justice Alito, all by himself said this would be constitutional. Well, Congress, or some folks who were in favor of modifying this kind of statute, introduced House Bill 5566 called the Animal Crush Video Prohibition Act of 2010. It was an attempt to tie these crushed videos into obscenity and sex. It was limited to intentional acts of extreme animal cruelty. Crushed videos were the target, and it even had language, the statute even had language suggesting that such crushed videos might be obscene. My take on the constitutionality of this statute is that it is not going to turn out to be a viable statute constitutionally. And that's because when you consider the analogy or the supposed analogy to child pornography in the Ferber case, the Supreme Court emphasized the unique nature of the state's independent interest in children and in protecting them from child abuse, and depictions, child pornography was viewed as such a crucial part of preventing child abuse itself that the Supreme Court said this is sui generis. And the court also in the Ferber case said that another reason we don't want these depictions to be out there is because children grow up and these will constitute permanent records of their participation in these sexual abuse settings. Now, try to think about those considerations in connection with animal cruelty. We permit cruelty to animals in many circumstances, including hunting and slaughter for food, but we never allow child sexual abuse, so that the interest that government has in preventing cruelty to animals is substantially less than the interest in preventing child sexual abuse. And animals do not have psychological harm and are also not affected by depictions alone. It's only the conduct. So I think this statute, if it ever gets past the Senate, is not going to pass First Amendment scrutiny. The second case I want to talk about is the Humanitarian Law Project case, because this involves a federal statute, 18 U.S.C. 2339, which makes it an offense to knowingly provide material, support, or resources to foreign terrorist organizations, which includes property or service, meaning financial services, lodging, training, expert advice, or assistance. Violation of this statute requires knowledge that a foreign group has been designated as a terrorist organization for its commission of terrorist acts. It also requires that the person who wants to provide these services must act in coordination with or under the direction of the foreign terrorist organization. In other words, it doesn't apply to independent advocacy. The free speech background here is based primarily upon the famous Brandenburg decision, which is a successor to the clear and present danger jurisprudence of the United States Supreme Court. An individual can only be liable, if you will, or can only be punished when he or she incites violence or advocates illegal conduct when that person intended to do so, and it was likely that illegal conduct or violence was likely to occur. That places a very significant burden on government to justify restrictions on high-value speech, and surely high-value speech, well, the highest value speech is political speech, and here we are talking about political speech. In this particular case, the plaintiffs wanted to facilitate only the non-violent lawful purpose of these groups, and the two groups were the PKK, the Kurdistan Workers' Party people, and Liberation Tigers of Tamil Ilan, the LTTE. The PKK was seeking an independent Kurdish state in Turkey, and the LTTE was seeking an independent Tamil state in Sri Lanka. In this particular decision, it was a 5-4 case. Opinion written by Justice Roberts. The Supreme Court held that we cannot avoid the constitutional question raised by interpreting the statute narrowly. We can't interpret the statute as requiring the specific intent to require to further the terrorist organization's illegal activities. We cannot do that. So the question is it unconstitutional because it violates the First Amendment? And the Supreme Court held here the material support statute as applied to what these particular organizations wanted to do does not violate the First Amendment. Material support is not pure political speech, and more important, the Supreme Court, and this was the point at which the dissenters vehemently disagreed, the Supreme Court focused on the findings of Congress that terrorist organizations don't meaningfully segregate their support of legitimate activities from their support of terrorism. And the two groups here were, in fact, deadly groups. So Congress went on further to say that it had, the congressional findings were to the effect that material support of the kind proposed by the plaintiffs here could further terrorism by foreign groups in many ways. Among other things, it frees up resources to use for terrorist purposes, and also it confers legitimacy on these foreign terrorist organizations. There was also, in addition to the congressional findings, an affidavit submitted by the State Department, the so-called McCune affidavit, to the effect that all contributions to foreign terrorist organizations further their terrorism. Putting it all together, Congress and the executive are competent to make these determinations. 3 justices dissented here. Breyer wrote the opinion with Ginsburg and Sotomayor, interestingly enough, dissenting. This is the statute, in fact, is unconstitutional. We could avoid the constitutional question by construing the statute more narrowly, but the majority didn't want to do it. It violates the jurisprudence of, the spirit of Brandenburg versus Ohio, and equally important from the dissenter's point of view, everybody agreed that strict scrutiny applied in this case. And therefore, the dissenter said, if strict scrutiny applies in this kind of situation, you don't defer to Congress. The court makes its own independent assessment of the factual underpinnings. And the dissenter said, Congress has really provided us with no sound empirical data to support the application of the statute to activities of this sort. And you certainly can't rely on this affidavit. You have to engage in truly searching scrutiny. Don't defer to Congress. The Supreme Court must make its own independent assessment. So there you have the material support statute as applied to foreign terrorist organizations held constitutional by the United States Supreme Court. The third case I want to talk about is the Christian Legal Society case arising out of Hastings College of Law. And the free speech background here is twofold. It turns out that there is certain government property which is very special from a free speech perspective. More about that in a little bit, but basically you've got traditional public forums, you've got designated public forums, and you've got limited public forums, which are special from a free speech perspective. That's one line of cases that is going to be addressed, or was addressed by the court here. The other line of cases involves a distinction between a subsidy or funding on one hand and disadvantaging, imposing a detriment on the other. At Hastings Law School, student organizations that received financial assistance from the law school and could use law school channels to connect with other students were called registered student organizations, RSOs. And they had to comply with certain conditions. They had to have a non-discrimination policy. No racial discrimination, sex discrimination, color, religion, national origin, ancestry, disability, age, and sexual orientation as well. That's the non-discrimination aspect of it. There was also an all-comers policy. RSOs had to let any student in the law school be a member of any organization and participate in the activities of the organization. You'll see, you can already guess that that might be an issue in terms of infiltrating and taking over a student organization with which views you didn't agree, with whose views you didn't agree. So comes the Christian Legal Society, which was turned down for RSO status. And its views, its charter, said that sexual activity is limited to marriage between a man and a woman. So that membership excluded students who engaged in non-repentant or unrepentant homosexuality, or who had beliefs different from those in the statement of faith, which talked about Jesus, the virgin birth, resurrection, eternal life, and the Bible being the inerrant Word of God. CLS, not surprisingly, was refused RSO status, although it did operate independently on the Hastings College of Law campus. The Supreme Court, in a 5-4 decision, Justice Ginsburg wrote the opinion, Stevens and Kennedy concurred, Alito, joined by Roberts, Scalia, and Thomas, dissented. In a nutshell, Justice Ginsburg for the court said two things. This policy, this all-comers policy, was reasonable. It made the facilities of Hastings College of Law available to all students. It was a very important part of the educational experience. There was no inquiry into motives that the law school would make into membership and the like. Furthermore, if you didn't get registered, if you were not an RSO, there were alternative channels available to CLS and other groups to communicate with students, school facilities, bulletin boards, electronic media, and the like. No empirical data to support the claim of CLS that there is a possibility of hostile takeovers. That was mere speculation. So the policy itself was reasonable. Furthermore, the policy was viewpoint neutral. Let's talk a little bit about forum analysis. A traditional public forum in First Amendment jurisprudence includes streets or parks. In such traditional public forums, government may not discriminate at all on the basis of content, period. A designated public forum is a governmental piece of property which the government says we are going to treat it as if it were a street or a park. We're going to open it up. We have no obligation to do so. We're going to open it up, and it's going to be the equivalent of a public forum. Imagine a municipality's auditorium in which it allows any groups at all to use for any kind of purpose. That turns out to be, in effect, a designated public forum. Here, too, you can't discriminate on the basis of content. There is such a thing as a limited public forum. That is best exemplified by forums at educational institutions, where those limited public forums are limited, if you will, to students and faculty at the university, and for those matters that might be relevant to the educational process, the students' interest, the faculty's interest. Those are limited public forums, and there you can discriminate by the very nature of a limited public forum on the basis of content, but you can't, and speaker, you can't discriminate on the basis of viewpoint. So that's why, in this particular situation, the court had to find as well that Hastings College of Law was not discriminating on the basis of viewpoint at all. This policy, the all-comers policy, was viewpoint neutral. Now let me jump right into the Alito, Roberts, Scalia, and Thomas dissent. This is fascinating. It turns out that there was a stipulation made by all the parties in the case that it was the all-comers policy that was basically being challenged, not the non-discrimination policy. But the dissenters said, wait a minute, this case is really about discrimination against religion. That was the original reason that Hastings College of Law said to CLS, you may not register, you may not be an RSO. In this dissenting opinion, it was a pretty nasty one, it basically accused, the dissenters accused Hastings College of Law of trickery, accused the College of Law of changing legal tactics and strategy in order to win the case and to hide the fact that it engaged in discrimination against religion. You get the flavor of it if I tell you that the dissenters accused Hastings College of Law, and therefore the majority as well, of giving into political correctness. At the end of the opinion, this is a serious setback for free speech. Don't change our law, and I don't know where this came from, don't change our law to conform to international norms. Don't know where that came from at all. Here is a reference thrown in about international law. Well, my last case, and I'm going to get over there and read something to you. The last case, which I will be very brief about because it is such a splintered opinion, you can't believe it. Or maybe you can. There is no opinion for the court. Kennedy handed down the judgment for the court. He was joined by Roberts and Alito in part, and you had other justices concurring, and you had 4 justices dissenting, and you probably can guess who those were. But here is the fact pattern in this case. And keep in mind that this is an establishment clause kind of case, and one of the major purposes of the establishment clause is to protect both religion and government from one another. And in terms of trends with the Establishment Clause, in the last 20 or 30 years, the Supreme Court has gradually, and sometimes not so gradually, allowed more and more government displays of religious symbols, such that they do not violate the Establishment Clause. And the process, the way in which it's done it, the court has done it, is by allowing government to desacralize the religious symbol, so that a creche is not predominantly a religious symbol. A menorah and a Christmas tree together are not predominantly a religious symbol. The Ten Commandments, a monument, is not predominantly a religious symbol. So when is a memorial cross that is erected to honor the dead, when is that a religious symbol? When is it not a religious symbol? Let me read you something very quickly, and then I'll tell you about the case, and we can open it up to questions. At the oral argument in the Salazar case, which is the one we're talking about, Justice Scalia asked the following: the cross doesn't honor non-Christians who fought in the war. Is that? Mr. Eliasberg, I believe that's actually correct. Justice Scalia, where does it say that? Mr. Eliasberg, it doesn't say that, but a cross is a predominant symbol of Christianity, and it signifies that Jesus is the Son of God and died to redeem mankind for our sins, and I believe that's why the Jewish war veterans interrupted Justice Scalia. It's erected as a war memorial. This was the cross in the Mojave Desert on federal property. It's erected as a war memorial. I assume it is erected in honor of all the war dead. The cross is the most common symbol of the resting place of the dead, and it doesn't seem to me, what would you have them erect? A cross, some conglomerate of cross, a Star of David, and you know, a Muslim half moon and star? Mr. Eliasberg, well, Justice Scalia, if I may go to your first point, the cross is the most common symbol of the resting place of Christians. I have been in Jewish cemeteries. There is never a cross on a tombstone of a Jew. Laughter. So it is the most, little parentheses, but there was a lot of laughter in the corner. So it is the most common symbol to honor Christians. Justice Scalia, he was annoyed. I don't think you can leap from that to the conclusion that the only war dead that the cross honors are the Christian war dead. I think that's an outrageous conclusion. Mr. Eliasberg, well, my point here is to say that there is a reason that Jewish war veterans came in and said we don't feel honored by this cross. This cross can't honor us because it is a religious symbol of another religion. Let me very quickly tell you about the case. You know what the result was, or you can guess. There was a cross that was erected in 1934 by the veterans of foreign wars. It was a Latin cross. It was can't tell whether it's 5 feet high or 8 feet high, in a remote section of the Mojave Desert to honor American soldiers of World War I. Now, the Mojave Desert is 25,000 square miles, which contains the Mojave National Preserve, which is 1.6 million acres. 90% of all this property is owned by the federal government, and this cross was put on Sunrise Rock, which was a granite outcropping in the preserve on federal land. It was not far from some private property. It was a couple miles away from a road, so you could see it from the road. Litigation brought by a former Park Service ranger, Buono, saying that this cross offends me and violates the Establishment Clause. Went all the way up to the Ninth Circuit. The Ninth Circuit found that this cross indeed violated the Establishment Clause. There was a lot of debate in Congress about that. Congress passed some legislation saying we're not going to use federal money to move the cross, this, that, and the other, and finally here was the solution. There was an agreement that was made for the federal government to sell this little bit of land to a private person. And that would, as a result, be constitutional, because now you've got the government out of the business. You transfer the land and the cross is there. The Ninth Circuit held that that attempt was unconstitutional. It violated the Establishment Clause because it was still an endorsement of religion. The Supreme Court reversed the Ninth Circuit, said basically that the Ninth Circuit took too narrow a view of the context of the land transfer statute. So the Ninth Circuit was supposed to get this back and pretty clear hints in Kennedy's opinion, reconsider this and find that this statute, the land transfer statute, is constitutional. You had in this case other justices who said, the 4 in dissent said, the land transfer statute is unconstitutional, constitutes a violation of the Establishment Clause. Interesting, you had Thomas and Scalia saying, this guy Buono didn't have standing in the first place to do this. And notice if a person doesn't have standing to make an Establishment Clause challenge, then the issue never gets before the court, and whatever the government has done stays the way it is. So a very splintered decision. Pretty clearly, there were at least 4 justices who would say that the cross itself probably would be constitutional, but they didn't have to do that. In this case, they focused on the land transfer statute itself. And there you have it for 4 very interesting and important First Amendment cases in this last term. Thank you. Open up questions? Questions, comments, observations? Ready to eat?
I guess if you could, when you were discussing the Cross the Mojave Desert case, the question that came to my mind, you kind of addressed at the end, is why a former Park Service ranger had standing in the first place to bring the case. So if you could, 7 justices seem to think you did, why, if you could address why that is.
Well, the precise standing issue that 7 of the justices thought was pretty clear was whether Buono, who had won on the Establishment Clause challenge to the cross in the first place, had standing to go to the court and ask the court similarly to strike down the land transfer statute. And 7 justices didn't think there was any such problem in doing that. However, the 2 justices, without much explanation, that's Scalia and Thomas, said there was no standing there. And in certain Establishment Clause standing cases, the Supreme Court has cut back to some extent on the notion of standing. The Hine decision of a few years ago at the federal level. But notice the strategy. If there is no standing, as I said a little bit before, you don't get into court and you don't challenge the Establishment Clause aspects of the government's conduct. By the way, Buono regularly came to the Mojave Desert, and he regularly would see this. So that probably would be enough to confer standing on him in connection with the original lawsuit.
In terms of the Stevens decision, you mentioned that you didn't think that the crush video statute was going to be able to stand. Given the definition of obscenity and then the fact that crush videos are primarily sexual fetish videos, wouldn't it be easy to squeeze those into the box of obscenity and just regulate them rather easily as an unprotected form of speech?
The interesting point, the problem is that lots of things may be sex fetishes. I understand that shoes are, certain clothing may be, almost anything can be fetishized. So the real question is, from as a matter of First Amendment principle, how do you distinguish crush videos? Now keep in mind, and maybe I didn't make this clear enough, there is simply no question at all about the power of the federal government and the states to prohibit the conduct that is cruelty to animals. That's not the issue. There was not that issue in the Ferber case involving child pornography either. You could prohibit sexual abuse of children. The issue always is the communication, the depictions, and the descriptions. And that's the only issue. If I didn't make that clear enough, I'm sorry.
No, I was more along the lines of they've, as I recall, Florian's interest, part of the definition, or the way that the definition has been fleshed out, is a morbid unhealthy curiosity in sex, and some of them have tied in. There have been some definitions that have been given as violence inflicted as a form of sexual pleasure within those, because they've used it as a morbid curiosity in sex, and they've tied in, I believe, violence and other aspects in that definition of the Florian's interest.
Well, I'm not sure that violence is a necessary part of that inquiry. In fact, Congress tried to tie these crush videos into obscenity, because obscenity is clearly an unprotected category, and the closer you bring what's being regulated or prohibited, the closer you bring it to obscenity, the more you hope you'll get some of those obscene penumbras and emanations applicable. Keep in mind, interestingly enough, that some justices are interested, apparently, in violence. Now, let me explain what I mean. The court granted cert a little while ago involving violent videos for children. And you probably know there was a Seventh Circuit decision in Kendrick, 8 years ago or so, in which Judge Posner for the Seventh Circuit held that violence is a part of life. You can't reason by analogy to obscenity and say that children can be protected from depictions of violence at all. So violence standing alone, depictions of violence standing alone are not constitutionally protected. Standing alone, they are constitutionally protected. I'm not talking about snuff videos or anything of that sort. We're talking about the conduct itself. We're talking about depictions. There was a woman in the back. Go ahead.
I was under the impression that the Ten Commandments could only be shown if it was part of other depictions of other religious types of things, and that there was even a federal judge that was taken from the bench because he refused to uphold that. Is that true?
Well, you're right. There are 2 or 3 major Ten Commandments cases where the Ten Commandments are displayed in a classroom or in a public school. The Supreme Court struck that down as violative of the Establishment Clause. Where the Ten Commandments were displayed in a courtroom or in a court building alone, that was struck down as well. Now, the tricky issue arose in the Van Orden case, a 5-4 case, in which Justice Breyer, for some strange reason, joined the majority and said that a Ten Commandments monument on the grounds of the Texas State Capitol, surrounded by 20, 30 other monuments, if not more, did not violate the Establishment Clause. Those monuments went back, speaking of the Ten Commandments, to the movie. The country was in a Ten Commandments buzz, you know, way back when, in the 50s, when the movie came out. You know Charlton Heston's Moses, don't you? You know that. So there was a movement 30, 40, 50, 60 years ago to get a lot of these monuments out there. And Justice Breyer, in his joining the majority, that's the Van Orden case, he said, we're not going to go over. He couldn't stomach the possibility, the prospect of a headline, that's my interpretation, Supreme Court strikes down Ten Commandments. He couldn't take that. That's what I think where Justice Breyer was going with it.
Chris, I may have one case and one oral argument mixed up, but I vaguely remember when the case involving the necessary proper clause was argued. Then I believe then Solicitor General Kagan sort of gave away a possible Commerce Clause basis or something like that, and tried to and expressly relied only on the necessary proper clause unfettered. Do you think that was a case of bad? I mean, if I'm remembering it correctly, was that case just a bad arguing, or, could they have linked it to one of the express provisions?
Well, that's the question, right? So civil confinement, how would you actually connect that to some sort of justification under the commerce power? It's not quite clear how someone who would be released, who would have a threat of sexual violence is necessarily a commerce clause issue in and of itself. Of course, the underlying crime for the reason a person could have been put in jail might be a commerce clause violation, or the law would be justified under a commerce clause, the reason a person was in jail in the first place. And then the argument would be that you have a predicate of the Commerce Clause, and therefore necessary and proper execution of that criminal statute is not just imprisonment, but it's subsequent civil confinement. It's the imprisonment. Once you're in custody of the federal government, you could argue there's a necessary and proper connection to that that might lead to civil confinement. But that's completely contingent upon the underlying criminal statute being based upon the commerce power.
What was he? What was he in jail for?
Oh, there's 5 plaintiffs in this case. I think they're in jail for a variety of reasons, which was the problem here, right? I mean, what is the sort of underlying constitutional basis for the imprisonment? It could be many different things, and it doesn't really matter to the civil confinement, because the argument is that the reason for the civil confinement is unrelated to the reason for the underlying imprisonment. Right? It's not like they were initially imprisoned because they were prone to sexual violence, and therefore the continuation of imprisonment can be justified based on the initial criminal statute. This could be someone thrown in jail, again, for stealing mail. In jail, they're diagnosed with mental illness, and it's recognized that in their past it has some proclivity to sexual violence. Right? So there's no connection, no necessary connection. And again, that's what the student case are demanding, that there has to be some sort of connection there. But a connection is completely contingent on what the underlying crime is, and for the decision to make any sense, or for the criminal civil confinement statute to make any sense, it sort of needs to be detached. Unless you create little mini civil confinement statutes for every possible reason you could be in jail, that just wouldn't be feasible. It's just a weird situation, really. That I think the court generally thought this is something the federal government needs power to do. The legal justification for it was awkward, to say the least.
Was there also some federalism issue there? I haven't read the opinion for a while.
In terms of?
In Comstock, because what we're talking about is affecting the state's power as well over these people who have served their federal sentences.
Yeah, so federalism in terms of trying to raise questions about his state autonomy being infringed upon, because again, the state civil confinement has been reviewed just under a basic individual rights claim. Has been upheld. So the state has the power to do it. The argument is these are situations the federal statute enters in when the states are unwilling or unable to step in. Now I will say, I referenced a couple of the concurring opinions as well as the dissents. There's very strong federalism language in that. So Kennedy says, I'm going to silence this opinion. But let's keep in mind that whenever you have a situation like this is a federalism issue. We actually need to bring the 10th Amendment to the analysis. He just thinks there's still justification there. So again, lurking in the background is really a basic question about the scope of federal power vis-a-vis state power, the question of federalism, the question about stepping on state autonomy. It wasn't in the foreground for the opinion of the court.
You had talked about how McDonald and Heller were sort of very originalist opinions, but written on originalist grounds, how do they sort of square the seeming militia purposes of the Second Amendment with, holding a broader individual right?
Right. So you have some tension in the Second Amendment with the text, where the preparatory clause references the militia, and then it says there's a right to bear arms. The question is a right contingent on being part of a militia, being connected with militia or not? And that essentially was a Heller debate. Justice Scalia wrote the opinion of the court in Heller, and he said it can be detached. There is a principle of a right to bear arms. That is actually a principle against oppressive government, not necessarily just serving a militia. And that he has extensive documentation and framing to demonstrate this. And Justice Stevens, who wrote the main opinion for the dissenters, just took issue with that. And along the lines that you suggested is saying that, yeah, there was a right to bear arms, obviously it's in the Constitution, but it's completely connected to, and it was understood to be connected to, some type of service in the militia. Now again, it's interesting, because once you move to the McDonald case, the militia rationale is less clear in the context of the 14th Amendment. Because one of the key points for the 14th Amendment was Reconstruction era. And one of the ways in which the white South sought to oppress the newly freed slaves was in fact to take their arms away. And taking their guns away from newly freed slaves was a way to oppress African Americans in the Reconstruction era. So there actually was some motivation in the drafting of the 14th Amendment, as well as the major civil rights statutes around the time, which are often seen as helping to illuminate what the 14th Amendment was meant to do. That there was a sort of right to have arms for self-defense. And again, that's not necessarily connected to service in the militia. So again, this is a tricky thing about originalism, right? You have different eras of history you can go to. There could actually be, arguably, a different Second Amendment as applied to states than there is applied to the federal government, meaning there's a different Second Amendment standing alone versus Second Amendment that would be the 14th Amendment. Courts, partly for logistical reasons, aren't necessarily going to go down that road of creating different amendments, even though a strict originalist interpretation, it could logically make sense, and it could actually strengthen an individual right under the 14th Amendment more strongly than just based upon the Second Amendment.
We all set?
Yeah, one question I had along the lines of McDonald's, and it's one thing that we've been seeing since kind of been coming up at the state level. Given the language that's implied in terms of placing restrictions on the ability to carry weapons in governmental buildings, restrictions in certain office locations as well, it kind of implies the right to take the gun out of the home. And we're seeing a lot of restrictions, or we're seeing a lot of challenges now that Chicago's current gun laws, which require you to have handguns in the home, is unconstitutional in light of the language from that opinion. How much do you think it's opened the door for challenging even reasonable restrictions on handguns to keep them inside the homes, given the broad language that the court was using?
Quite clearly, Heller and McDonald agree on the fact that handgun in the home for purposes of self-defense is constitutionally protected. Then the question becomes moving beyond that. Right, so some of the current Chicago gun bans, they have questions about, well, can you walk to your garage with the gun, right? Would that actually go beyond the scope of the ban? And some of it is sort of just silly little hypotheticals you can spin out based upon the letter of the gun regulation versus what might be constitutionally upheld. This is, I mean, one of the main critiques of Heller, even for gun rights people, is that it leaves a lot open. It identifies a core, and it identifies an extreme where there is no constitutional protection. And then it allows a lot of latitude in the middle in which you're going to have a dialogue between localities passing gun regulations, those gun regulations getting litigated in courts, and then courts drawing lines based upon this very rough guideline of you have a core protection and you have some extreme cases that won't be protected. And then it's a question of what the Supreme Court wants to actually hear as it filters out and what they let stand. So it's going to be, I mean, at least for the foreseeable future, this sort of negotiation through litigation, I think might be one way to think about it.
Correct me if I misremember this, but I think that Justice Breyer, in his dissent in Heller, wanted to use rational basis review, and the majority in Heller rejected that. So we know it's not rational basis review. We know it's going to be some sort of heightened scrutiny. Who knows whether it's going to be strict scrutiny or something in the middle. Do I remember that?
Yeah, the majority explicitly rejected a clear standard. I mean, the question of standards, they did. The dissent called them out on that, and Scalia said, we're deciding not to set a clear standard. Again, we tell you what's unconstitutional, we tell you what is constitutional, and we're not going to do the hard work in between. And not even setting the standard of analysis going forward. So I mean, quite clearly, it's in some ways just an initial foray into something that they recognize is going to be ongoing for generations. Which, I mean, again, we can be critical of that, right? Courts need to set down clear lines, lower court judges like that, perhaps we could say. I would also say that there is something perhaps appropriate about a court setting up, clearly setting aside something and saying this is constitutionally protected, but allowing the process of local governments and state governments and courts to actually work through some of these problems. So these problems are hard, right? There is clear safety issues here. There is a constitutional issue here. And the lines between them, they're going to be necessarily arbitrary. And a court just sort of laying down the law would be just a court laying down a law in a somewhat arbitrary manner. This doesn't strike me as necessarily a wrong way to approach this issue, which again is this is the basic thing about gun rights. It's new. right? The Constitution's been around a long time. This is essentially a new issue for the federal courts to be dealing with.
It reminds me a little bit of one of your areas of expertise, the court's response to Brown 1. You know, all deliberate speed. We know what Brown 1 held specifically, but we didn't have any real idea of its implications, and the court was going out of its way to make sure, for lots of reasons, that the country and school districts and everybody could deal with it, and it took a long time to do that.
I think that's right. I mean, so Brown scenarios, you have concerted opposition and how you deal with opposition.
Right.
You can do it through a negotiated process of all deliberate speed. Here, I wouldn't say it's necessarily concerted opposition. I would say it's just uncertainty in terms of how they draw these very difficult but important lines. So I think a different sort of basis for judicial ambiguity as a sort of way of moving forward. Sanford, do you want to jump in?
I was just wondering whether either of you thought there was any chance that any member of the current court might have second thoughts about Citizens United in light of the fact that at least part of the, as I understand, part of the rationale of Citizens United was the belief that if you had disclosure, then marketplace of ideas would be okay. But at least in this election cycle, we've had lots of spending and not very much disclosure. I wonder if there's any chance of second thoughts.
The second thought, I mean, disclosure is allowed under Citizens United.
Right, but it's not. But
it's not happening. So the question
it's not happening.
So the question is, when they passed it, when they issued that decision, did the majority actually think that Congress would take up their hint of actually doing disclosure, and that they thought there was a constitutional right here, but the system would work better with some sort of disclosure? I'm not sure. I mean, Thomas actually dissented at that point, right? The disclosure question was 8-1. Right? Thomas actually thinks that disclosure would be unconstitutional, I guess would be his view. So yeah, I don't actually know about that. I mean, the decision did actually put a strong emphasis on disclosure as a beneficial way of dealing with this problem. So the fact that it hasn't actually worked out that way, perhaps. Although I don't see these just as being necessarily regretting that vote. If anything, Obama's denunciation probably made him like it more.
Shall we make this the last question?
I have a question about the 10th Amendment case. Can you just explain in more detail the court's reasoning that the claimant had standing? And then, was that case just a standing case, or did they decide on anything substantive?
So this is the one that's forthcoming we're talking about, right?
Yeah.
So this is the one the Supreme Court just accepted cert. It's called Buono versus United States. It came up through, I think, the Third Circuit. And so the Third Circuit decision said that we think there might be a constitutional claim here under the 10th Amendment. There actually is some language in that decision referencing that there's something strange about going after this individual with a treaty of chemical weapons, right? But this person doesn't have standing. So the decision, the holding, is a standing holding. Individual does not have standing in the 10th Amendment, but I think it was framed somewhat tentatively, again, because this is a sort of a strange new issue. The 10th Amendment is typically brought up by states when the states are challenging federal law. So for an individual to actually state his or her claim on the 10th Amendment is sort of novel. So I think they said, according to our best reading, we don't think they're standing, but you can see why this would be something the Supreme Court might want to take up because it's sort of interesting. But this sort of brings us full circle, I think, to the very first question, which was a standing question on the First Amendment case. Standing oftentimes is an indirect way in which justices express opinions about the merits of a case. So even though oftentimes the merits don't get fully played out if the decision is based upon no standing, you see courts manipulate standing, right? Expanding it or contracting it. Oftentimes it sends a signal of what they think. Right? So rejecting standing in the Establishment Clause case is partly the justices who find no standing there are skeptical about the claim itself, even though they might not say so in so many words. I do think this is an interesting case in which there seems to be a viable claim that there is standing in this case. I honestly wouldn't be surprised if the Supreme Court found there was standing here. In part, sending a signal that the majority of the court is interested in the 10th Amendment, even if they don't side with the petition in this case. So it is just a standing case, but like all interesting standing cases, there's really a lot more behind the scenes than just a technical standing doctrine question.
What would be the argument, 10th Amendment argument, if the case went if the person did have standing?
So assuming there is standing, what are the merits of the 10th Amendment claim?
Yeah.
It's just saying that going after someone for trying to poison a husband's lover is a state issue, that this is the state system. And again, this person could have been tried in state court, could have been prosecuted in state court. This is a state issue. The federal government stepping in on something which so clearly is quintessential police power of the state, that the federal government, at least in this usage of the treaty, is going beyond the bounds of what's appropriate to use the 10th Amendment as some sort of barrier trying to protect some sort of core responsibilities of the state.
I'm curious, I know all too little about international law and treaties, but I remember that the threshold question in these cases is whether the claimant is arguing under a federal statute that is implementing the statute, the treaty, or whether the claim is that it's a self-executing treaty. You know, I mean, I haven't read this paper.
I don't recall. My understanding of it is somehow self-executing. I'm not sure how that would fit into the issue.
Well, because there was a case a year or two ago, the Medellin case, where the court said that the difference is a crucial one, and it found that there was nothing, you couldn't use this particular treaty in the absence of federal legislation. Thank you.
Again, thanks everybody for coming out. Please, we've got the room for another half hour. There's plenty of food. Feel free to dig in and mingle. And again, on behalf of the American Constitution Society and the Federalist Society, we'd just like to thank Professor Nahmod and Professor Schmidt for participating in the discussion today.
And let's not forget the Institute for Law and Humanities, which was a co-sponsor in the background.